Hi, this is Attorney Mike Garland coming to you from Chicago as usual, and today we're going to do a good old-fashioned sovereign citizen court fail. It's interesting stuff, and we're going to call this one Sovereign Citizen Court Fail number 21. Let's do it. From the secret headquarters of the Sovereign Citizen Patrol, initiating video production sequence. We are no longer playing, so let's get revved up. It's time for Law Talk with Mike.
Out of this courtroom.
I'm denying that because what you have said here shows
you
that
are
you
in violation.
No understanding.
You're in violation of my rights.
Laws.
The oath that you took, you're in violation of. I am demanding my Sixth Amendment right to go pro se, and I would like this attorney out of this courtroom.
I understand your request.
Okay, we've been through this a bunch of times. He has to do a FREDA inquiry based upon case law to make sure that this guy's competent and understands what his defense is. You'll see through this video that he clearly is not competent to defend himself. His attorney doesn't say much. He can't do it, and it's painful to watch how he handles it with the judge.
And I respect that you think that you understand this process. Clearly,
Do
by
not
your
respect
remarks,
me, Your Honor.
you do not understand, and I am duty-bound to make sure that you understand before I allow you to go pro
I
se.
perfectly understand. We established that the last time I was here.
Well, clearly your remarks today suggest otherwise.
According to you,
uh,
not according to the law. We're
it's
talking
true.
about the law. We're talking about rights.
I first of all, I kind of like the judge. He's pretty nice, but he's not having it at all. And then he says, according to you, not the law. Well, he is the law. He's the judge, duly appointed for this circumstance, and he's the one who makes the decisions of law in this proceeding. It's that simple. The judge basically is the law, and in terms of interpreting this scenario.
We're not talking about what you think. We're talking about what is
Future,
right,
you can
fully
go
mine.
And
That's what we're talking about here today. And that's what you're supposed to be talking about here today.
Mr. Luke, you may proceed.
Thank you. Judge, I had read the information in file 17 CF 1013. The information is comprised of 2 counts of fraud against a financial institution. I'm going to read those elements, and I'll make the elections that are required that I think that fit the proof that the state has. Number 1, the defendant, Gregory Rael, obtained money owned by or under the custody or control of a financial institution. Financial institution means a bank or a credit union chartered under the laws of this state, another state or territory, or under the laws of the United States. Element number 2, the defendant, Gregory Rael, obtained by means of false pretenses or by use of any fraudulent scheme, money or a monetary instrument. A person obtains money by means of false pretenses or by use of any fraudulent scheme when, with knowledge that it is false, and they act with intent to obtain money. And finally, it says if you're satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty.
In that those elements are the elements that apply to both counts 1 and 2 in that information?
Yes, those would be elements that would fit for counts 1 and 2.
This is interesting. I can't quite figure out what this hearing is. I've seen it to the end, but I can't quite figure it out. I would think it's an arraignment because they're reading the charges, but we seem to be farther along. He's obviously incarcerated, and they're coming at it from the perspective of jury instruction. So this might be a pretrial conference setting up for the trial, and you're going through the allegations and the proof you have with the judge. You're setting up what you need to proceed to trial.
The defendant's charged as a party to the crime, but I don't know that that's particularly relevant. He was a principal actor in this with the state's evidence will show that he was a principal actor.
Thank you. And then if you can read to Mr. Rael the information in the other file and then indicate the elements as the state intends to prove them.
All right.
I object.
And don't forget to hit like and subscribe, or the dogs get it.
I, John
object to these
Woodruff,
readings, Your Honor.
Assistant District Attorney for Brown
I
County,
understand.
Wisconsin,
No, you do not understand.
hereby inform the court that count one, the above named defendant on or about Tuesday, October 10, 2017, in the city of Green Bay, Brown County, Wisconsin, did intentionally cause bodily harm to Dan Magnan, a law enforcement officer, without his consent, and at the time of the act, the defendant knew or should have known that Dan Magnan was a law enforcement officer, and the act was in response to any action taken by a law enforcement officer in an official capacity, contrary to section 940.203, parent 2, Wisconsin statutes, a class H felony. And upon conviction, the defendant may be fined not more than $10,000 or imprisoned not more than 6 years or both. Count two, the above named defendant on or about Tuesday, October 10, 2017, in the city of Green Bay, Brown County, Wisconsin, did knowingly resist an officer while such officer was doing an act in an official capacity and with lawful authority, to wit, arresting him, contrary to section 946.41, parent 1, Wisconsin statutes, a class A misdemeanor, and upon conviction, the defendant may be fined not more than $10,000 or imprisoned not more than 9 months or both. Count three, the above named defendant, Gregory Real, on or about Tuesday, October 10, 2017, in the city of Green Bay, Brown County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to section 946.49, parent 1, parent B, Wisconsin statutes, a class H felony, and upon conviction may be fined not more than $10,000 or imprisoned not more than 6 years or both. That's it.
Thank you. And if you can identify the elements for each of those offenses, please.
Yes.
It's interesting. It starts with, it reminds me of Anthony Williams. I have a video for Anthony Williams on a mortgage fraud scheme. That's pretty good. You might want to check it out. It starts with sort of a fraud against a financial institution. So he's doing something in order to get money that's not his. That's the initial crime. It looks like when they go to arrest him, he assaults the officer, then he resists arrest, then he violates bond. So it sounds like the fraud sort of scheme is the underlying crime here, and then of course when they go to bring him in, he doesn't cooperate, and then he violates bond.
Well, I'm reading directly from 1240C, which is the pattern jury instruction for battery to a law enforcement officer. Element number 1 that the state must prove: the defendant caused bodily harm to, in this case, Dan Magnan. Cause means that the defendant's conduct was a substantial factor in producing bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. Element number 2, Dan Magnan was a law enforcement officer.
The record should reflect has stood quietly and appropriately during that time. He is accompanied by officers here today. Mr. Rael, have you heard the presentation that the state has made with respect to the information and to those elements?
I do not consent to the reading of those charges.
He objected when they started reading. He doesn't consent. That is just too good. It's classic sovereign citizen. Although this is up a notch. Usually we're doing parking stuff or whatever, but these are much more serious charges. And your consent is not required, my friend.
The state's attorney, I would love the state's attorney to prove to me that he has legal authorization to even charge me with any crime.
Those shackles on your wrist and that orange suit should be proof enough for you.
I've heard his gibberish, as you put it, and I would like to myself.
Oh, that's rich. He's calling that gibberish. I will say the reading was awkward. It was, but they're going through a statute and they're just trying to fill the forms. But it wasn't like natural language. I'll give you that. But it wasn't gibberish. I picked up exactly what's going on. You were involved in a fraud scheme, and then you and then you resisted arrest, and then you violated bond. Plain and simple.
As for the record, I demand that all oral, verbal, written, signed contracts, law, etc., that I have entered into with this court, signed, spoken, be revoked, stricken from all records.
That's cute. That's a nice little demand. The problem is there aren't any contracts that you've entered into. Your demand is meaningless. There's no contract predicate to charging you with a crime. You committed a crime. They're charging those elements. If they can prove them, you're going to be found guilty. It's that simple. Contract has nothing to do with this, except maybe in the underlying offense if you are committing fraud via contract or something like that. But you don't need to contract with the government. You just need to be subject to their laws by being in their jurisdiction.
I do not wish to enter any further any contracts, laws, statutes, rules, regulations, or codes orally, verbally, and or written.
Yeah, that's cute, but irrelevant.
With or without my knowledge.
Well, there you have it. Just a quick one. I've meant to do that clip many times. It's not the most fantastic, but I do like seeing a sovereign citizen try this in a different context. It's not the usual driving without a driver's license routine, or I'm attempting to travel. It's full on trying to deny jurisdiction of a court when you're doing some nasty stuff. Can you imagine if the law actually believed these things? Okay, well, nobody has the authority to stop you from committing fraud. Nobody has the authority to arrest you. Carry on. Quickly becomes a might makes right anarchy state. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.